Second over the hearing, Robert Archbald Gilchrist Sinclair against Ian Domaille and 3 others.
Mr. Lloyd.
Good morning. I'd like to start this morning by touching briefly on the factual findings again. Now, I took you yesterday to the findings in the Royal Court judgment at paragraphs 363 to 367 and 397 that the operational difficulties caused by Mr. Sinclair's non-cooperation were a threat to AHL's business and were causing grave harm to the company. There was a question about whether the evidence justified the findings of grave harm. The short answer is, those findings were the subject of a specific ground of appeal to the Court of Appeal. That ground of appeal was dismissed, and permission was not sought or obtained to renew that ground of appeal before this court. Mr. Sinclair only sought and obtained permission to appeal on the proper purpose and the price grounds.
Where was the ground in the Court of Appeal judgment?
Well, I'm just going to come to
You're coming to that, okay.
Yes, my lord. To give some reference, I won't have time to take you up, but if you go to paragraph 48 of the Court of Appeal judgment, which is page 1836, it records that under ground 4, Mr. Sinclair objected to the Royal Court's, this is page 1836, my lord, objected to the Royal Court's findings that Mr. Sinclair's conduct had caused grave harm to the company. At paragraph 52, the Court of Appeal accepted that the Royal Court was fully entitled to accept that Mr. Sinclair's failure to cooperate was causing significant operational difficulties. At paragraph 54 of the Court of Appeal judgment, it is recorded that Mr. Sinclair also appealed on the basis that there were alternatives available to solve the operational difficulties other than the share issue. And paragraph 55 of the Court of Appeal's judgment, which I invite the Court to consider in due course fully, systematically goes through why each of these alternatives were not viable, so that the share issue was the only alternative. There was no appeal against these findings. This court must therefore proceed on the basis of these factual findings.
I don't think anything turns on it, but it's just a question of nuance, really. The significant operational difficulties sounds a rather more accurate description than grave harm. That was what, and this, as you pointed out, is how the Court of Appeal described it.
Well, my lord, I'll come, my lord, a little bit more to how, if your whole business is providing services of this nature, it's not a minor sort of operational issue. It's a serious threat to the business.
Okay.
I will come to it a little bit more in a minute. But the point I'm making now is not an arid technical point. The Royal Court had the benefit of reading hundreds of documents, reading all the witness evidence, hearing live evidence from the directors and Mr. Sinclair, as the Court of Appeal pointed out at paragraphs 52 and 13 of its judgment. There was a 5-day hearing. The evidence is summarised in the course of hundreds of paragraphs of the Royal Court's judgment. For your note, we draw particular attention to paragraphs 62, 67 and 80. There was extensive cross-examination of Mr. Sinclair, by way of example only, on the fact that he was able to fulfil commitments as a director of non-Artemis companies during the relevant period. Yes. So transcript of his cross-examination at pages 198 and 199. With the greatest of respect, there would be a real danger in this court engaging in what the authorities describe as island hopping, questioning factual findings on the basis of a small selection of the evidence. To take another example, the directors were not simply waiting on Mr. Sinclair to complete a form to open a bank account. There were a large number of outstanding requests, and for your note, there is a table at page 1439 of the bundle, of the outstanding requests. And grave threat is not hyperbole when one considers the nature of AHL's business. Its entire business is providing fiduciary services for clients, affecting transactions on their behalf. For example, purchases of land, entering into leases, etc. Acting as trustee for them, providing due diligence documents in response to requests from authorities and banks, opening bank accounts, etc. All of these activities required CDD from those who had a greater than 25% shareholding in AHL. When Mr. Sinclair refused to cooperate, AHL was hamstrung in its ability to provide basic services to its clients. And for example, to see Ms. Guillou's witness statement at page 685 of the bundle. Reducing his shareholding to below 25% meant that AHL could provide services to its clients. Now, it's clear from paragraphs 12, 14, and 63 of the Court of Appeal judgment that the reason for reducing his shareholding to below 25% was because 25% was the Guernsey legal threshold for making a shareholder a controller who would be required to comply with CDD or AML. And criminal sanctions apply to fiduciaries like Artemis for non-compliance.
So say it was a Guernsey requirement.
Yes, we're talking here, not here about minor technical.
No, but I was just...
Where does it say that? Because
I don't understand,
63...
we were told yesterday this was sort of an internal thing from the New Zealand...
And 63 doesn't say that it's a
banks.
Guernsey legal requirement.
But if it was, it seems to me rather a point against you. If it arose from the definition of, or from what constituted control under Guernsey company law, then that would tend to suggest that the object was to change control of the company under Guernsey company law.
To answer to your latest point, the point is a worldwide one, not a specific Guernsey.
Oh, so it isn't Guernsey.
Not Guernsey specific.
Okay.
Does it include Guernsey? Are you saying there is something under Guernsey law that has significance in relation to the 25%?
Can we, perhaps I could, rather than paraphrasing it, I wonder if I could just refer the court to paragraph 12 of the Court of Appeal judgment.
Yeah.
That's as far as I'm going to take it to.
I mean, all that says is that in some cases, the requirements of banks and institutions who AHL would like to have as customers require AHL to fill out certain paperwork.
But does that requirement stem from the fact that somebody with 25% or more of the shares has a certain level of control over the company, which somebody with under Guernsey law, which somebody with under 25% does not have?
Well, paragraph 14 of the judgment goes on to say, it was the defendant's case and Mr. Sinclair's failure to cooperate was causing damage to the business, which risked losing clients. Advice was taken from Appleby, and a solution was proposed by which Mr. Sinclair's shareholding would be reduced to just below 25% in order to obviate the need for his participation in any CDD functions.
Yeah, but that's client due diligence functions. I mean, the answer to my Lord's question, surely, is that under Guernsey law and indeed under English law, somebody with more than 25% of the shares of a company has what's often called negative control, in the sense that they can block a special resolution.
Yes.
I mean, that shows, doesn't it, that the object of the resolution was to alter control of the company, level of control of the company.
Well,
it wasn't just to address an administrative question, as it were, free-floating requirement. The 25% didn't come out of nowhere. It came because of the Guernsey control requirements.
Well, my Lord,
Indirectly.
I'm simply going to refer for the present purposes on the last sentence of paragraph 12, which is divorced from the question of control. It's a question of persons with a beneficial interest of 25% or more to participate in the completion of the paperwork.
That's client paperwork.
Yes.
But it stems from the fact that under Guernsey company law and English company law, and many other countries, you cannot pass a special resolution if you do not control more than 75% of the shares of the company, so that somebody with more than 25% has the ability to block a special resolution and to that extent has a negative control over what a company does. And if you change that, if you take somebody from having more than 25% to having less than 25%, you change the control functions of shareholders within the company. You change the balance of power.
Well, my Lord, a reduction below 25% may have two consequences. One of them will be the consequence that your Lordship has pointed out. The other one is that the compliance issues which were causing a company grave difficulties would no longer need to be complied with.
Yeah, but that's not.
But the two are linked. That's the point.
Yeah.
They are linked, but the motivation, the purpose behind the exercise of the power was to address specifically this issue. I'm instructed that for high-risk clients, the percentage drops to 10% in terms of from 25%. So it's not direct. There's not a direct correlation between the 25% sort of
Sorry, I'm
threshold.
not sure I understand what.
Where it's a high-risk client, the due diligence requirements kick in for every beneficial owner of more than 10%.
High-risk client meaning, sorry, I'm not really sure. The client due diligence requirements of AHL come from the person who wants to use AHL's services. Yeah.
Yes.
So where does the 10% fit in?
And where's the evidence of it?
Yes.
What if somebody regarded AHL as high risk, they would require somebody with more than 10% to sign.
Yeah.
Is that the point?
The issue is not AHL being high risk; it's the client of AHL being high risk, and it would be
The beneficiary.
a beneficiary, and then a bank may impose these requirements in the case of a high risk client. At a
But do tell me, is there any evidence about any of this?
Yes. Well, we, as I said, we have paragraph 10, which deals with 25%. The 10% point.
Is it covered in the first instance judgment?
Yes. Page 1906 is the agreed statement of facts. If you go page 1906 of the bundle. In some cases.
Paragraph 12, is it?
Page 1906. It doesn't specifically mention the 10% point, if that was the question.
It's paragraph 12 there, is it?
Yes.
Yeah.
My point simply on the 10% was that it's not directly, in some cases, related to the question of negative control.
I'm still unclear as to the source of the obligation, or whether there was any obligation on Mr. Sinclair.
I have not stated, asserted that there was any specific legally enforceable obligation upon him.
You did when you started this little section of your submission say 25% was a legal threshold, but I think you've now moved away from that. And you're saying this was leaving aside the question of negative control through 25%, you're saying this was a corporate, a client due diligence.
Client due diligence. I think what I maybe on further analysis of, in face of the questioning from Lord Snowden, it's not a specific link between negative control and the due diligence requirements. The due diligence requirements happen to coincide, for most cases, with that 25% threshold, but for high-risk clients, it's a lower threshold, it's 10%, which banks might require a client due diligence on. So there's no necessary linkage in all cases, it just happens to be a coincidence.
Well, the 10% is the level at which, on a takeover offer, you can mandatorily drag along a minority shareholder. So there's it's just well known. There are, in company law, 3 critical levels which alter the constitutional balance of power within a company between the shareholders. One is 50% majority. The other is 25%, because that's the ability to block a special resolution. And the third is 10%, because if you have below 10%, if the majority accept a takeover offer, you can be dragged along. And the discounts that apply to minority shareholdings at those 3 levels differ accordingly. You're heavily discounted below 10%, you're somewhat discounted below 25%, and you're only discounted to a small amount below 50%.
Yes.
Is any of that wrong?
My Lord, no. From my experience, that is the case. The question was the linkage of the due diligence requirements with the percentages, and that's not something which, until today, I had tried to get behind. It may be that, my Lord, your connection is correct.
Can I just ask a question, another factual question, as we're sorting factual matters out? At 1370, paragraph 5.6, there's a suggestion that the majority shareholder would be disadvantaged because he could be called upon to to contribute further funds. And I was just puzzled about that yesterday, and I still remain puzzled about it today. Which would be a greater obligation on the majority shareholder than is currently the case.
My understanding is that there were 2 specific concerns. One is if there's a call on shares, it would be a greater call on him because of his greater shareholding.
Hang on,
Secondly,
these were fully paid shares, weren't they? The shares that were already in issue were fully paid shares.
Yes. Yes. It's that the GFSC, the Guernsey Financial Conduct, were investigating the company. There was a concern that they may levy a fine, and that fine would fall on shareholders according to their percentage holding.
Well, the fine would be. I mean, I don't know where the evidence for any of this is, but the fine would be presumably levied on the company.
It's not right, my lords.
Can I maybe clarify? It wouldn't be an obligation on the shareholder. It'd be an obligation on the company.
Yeah.
But the shareholders would need to contribute to pay that fine.
Why?
Pro rata to the shareholder.
Why?
I think, my lord, I will. It's lack of clarity about whether what I've said just before actually holds water. So I will.
I would just like to know whether that was totally wrong. That basis upon which the directors passed this resolution was just incorrect.
Yeah. Well, can I give you a reference? It's paragraph 385 of a Royal Court judgment, where it explains that purchase by the first defendant sufficient of the shares at market value.
Sorry,
Just one
could
second.
you give us the reference again?
Page 1812.
1813.
That's
12.
1812. It's a finding of the Royal Court. Would have encumbered the Mr Domaille with additional debt, and therefore would have meant he was less able to inject additional capital to AHL and or its subsidiaries in the event of the enforcement action resulted in the company and our subsidiaries requiring additional capital. They also found it would not be feasible within the requisite time period.
It seems to be a slightly different point.
That's a different one.
The change in shareholding would place a greater obligation on the majority shareholder than is currently the case, which would be a disadvantage. In the event that funds do need to be raised in the future, the change in shareholder would place a greater obligation.
Well, that's what it said in the minutes.
That's what it says in the minutes.
Yes, right.
But I mean, the point that my Lord Stevens made yesterday, there's no obligation upon a shareholder to subscribe to a capital issue in the future. It's just he has not. If you hold more shares, the shares are issued or are offered pro rata on a subsequent capital subscription. You don't have to take them up. It's a benefit if you have more shares, if you want to take shares, but you don't have to. So, I mean, at the moment, like Lord Stevens yesterday, I struggle to understand why that is an accurate statement in the minutes.
Yes. My Lord, I'm not going to be able to assist you, I think, further on that issue. The principal point, which I want to focus on, is that the minutes clearly show that the purpose was to solve the operational requirements, and that was the focus.
Well, you say that, but 5.5 says expressly that they could be issued to the majority shareholder only so as to dilute the shareholding of the minority shareholder to below 25%.
And it then goes on to make, actually, the point we've just been discussing, which is the limit for a controller for AML purposes in Guernsey, and is generally accepted as the limit internationally. I mean, the distinction between purpose and effect depends. If you're going to say something is simply an effect and not part of the purpose, you have to say it's not intended, it's not desired, it just is something that comes about as a consequence, but it's not something that you're actually aiming at. But here, it's plain that it was being deliberately, purposively aimed at. It is purpose, not just effect.
Well, the ultimate purpose was that the company wouldn't require his cooperation on CDD issues.
Yeah, but there's no doctrine that it doesn't have to, if something's part of the purpose, it doesn't matter, provided there's some ulterior end. Your distinction depends on it not being part of the purpose, it's simply being an effect.
Or
And
totally
you cite various
incidental.
cases in which it's said to be a byproduct that something happens. But it's not a byproduct here, it's the whole point of it.
It could be seen as maybe a means by which the purpose is achieved.
Well, what do you say about 5.5 of the minutes? That doesn't say it's just incidental. That says that the shares could be issued in order to, effectively, dilute the shareholding of the minority shareholder.
Well, I've previously, as I previously said, the findings of the Royal Court, as approved on appeal, was that the purpose was to address these operational issues.
But that's a legal question. I mean, the question of what the purpose is for the issue of shares and whether it's lawful or not is a legal question, which is why it's in front of us. We're not bound by that statement in the Royal Court's judgment. And the question of what is the purpose for an issue of shares and whether it's a purpose for which the power is conferred is a legal question. That's why we're sitting here.
Well, my Lord, perhaps what I best thing might be is if I move on, I'm conscious of time, if I move on to the proper purpose submissions I was in the middle of yesterday, so that I can make those submissions and maybe then tie it into the facts of this case. I'm going to start with the second proposition as I defined it yesterday, which is the lodestar for whether a director's purpose in issuing shares is permissible is whether it was a management purpose. Now, I'd like to look at Mills and Mills. The version in the authorities bundle only had one judgment of Lord Justice Latham, but we have now the Commonwealth Law Reports version with all 5 judgments of the High Court of Australia. It's been uploaded to the portal overnight, but we also have hard copies if the court would like that. We provide copies to my learned friends. And I just want to take the court to a couple of pages of one of the judgments of Mr. Justice Rich. So I don't know whether you have it available or whether you'd like hard copies.
It doesn't seem to have been uploaded, unfortunately, to us, to our folders.
There was an updated hearing bundle uploaded yesterday.
Could it be in that? No, but that's what we've got open.
Yeah,
That's what we're working from anyway.
we've got Saxon Woods, but
Yes.
We've got Saxon Woods, but that was
Yeah.
added earlier. Thank you.
This is the Commonwealth Law Report version.
Thank you.
Now, I want to take it quite quickly on conscious of time. This was a company with 2 classes of shareholder, ordinary shareholders and preferential shareholders. The directors resolved to distribute dividends to the ordinary shareholders and to satisfy the dividends by issuing fully paid up shares to the ordinary shareholders. If you go to the judgment of Mr. Justice Rich, it starts at page 166. On page 167, he says, first full paragraph, our business is the duty of saying whether the resolution.
Sorry, you're reading Mr. Justice Ridge.
Page 167.
Yes.
It's a paragraph starting our business.
Yes, got it. Thank you.
Whether this resolution was invalid on the ground it was animated by an improper purpose.
Just out of interest, before you get to that paragraph, it's perhaps not wholly irrelevant to read the first paragraph. Right. Perhaps the parties in this litigation could read the first paragraph of Mr. Justice Rich's judgment as well.
Well, if I had more time, I would have been. It would have been an amusing or relevant introduction. But the point I'm trying to make is that the directors contended they'd adopted the resolution because they thought the profit should be capitalised and distributed among the ordinary shareholders in the event of a winding up, presumably a solvent, just and equitable winding up. Whereas the appellant said that its purpose was to maintain the voting power of a managing director and or those likely to support him. If you go on to page 170, middle of the page, just after 2, in the present, Mr. Justice Rich says, in the present case on the facts, there appear to be only 2 sensible purposes or reasons which could have prompted the capitalisation of profits and distribution of shares. One purpose was within the power, the other was outside it. The purpose within the power was to confer upon ordinary shareholders a title to the fund pro tanto representing reserves of profits. The illegitimate purpose was to maintain the strength of the voting power likely to be used on the side of the directors concerned. And so the first purpose was a proper purpose because the distribution of profits is a matter reserved constitutionally for directors. The second was outward power because maintaining the voting power of the ordinary shareholders is an improper purpose because it's for shareholders to control the votes in general meeting. Now, all 5 of the judges upheld the trial judge's finding that the director's purpose was the first one, so there'd be no breach of the proper purpose rule. And the critical point in this case is that judges accepted that the directors squarely intended to alter the balance of power between ordinary and preferential shareholders. Ordinary and preferential shareholders ranked pari passu on a winding up, and issuing further shares to the ordinary shareholders improved their position on a winding up, which was the director's express purpose. And Mills & Mills was cited with approval by Lord Wilberforce, Howard Smith and Ampol, for example, at page 835 of the report. So we can take from Mills that the mere fact that the directors intend to alter the respective interests of different groups of shareholders will not make their purpose improper. Something more is required. One has to look at why they were altering the respective interests of different groups of shareholders. Were they doing so in order to arrogate to themselves a function that is usually preserved for shareholders? And there is extensive support in the authorities for the proposition that mere alteration of interests is not enough. One must look at why the interests were being altered. In Fraser and Whalley, the directors issued shares so they could control a forthcoming general meeting and defeat a shareholders' resolution for their removal. It was held that deciding the composition of the board is a matter for shareholders, and for your note, that is at page 2089. In Piercy and S. Mills, the directors issued shares to control a forthcoming general meeting to defeat a shareholders' resolution for the appointment of additional directors. Again, it was held that deciding the composition of the board is a matter for shareholders. Again, for your note, pages 2119 to 2120. In Punt and Simons, the directors issued shares in order to maintain the statutory majority to pass a special resolution to amend the articles. And it was held that the amendment of the articles is a matter for shareholders. Again, for your note, page 2110.
211?
2110.
Thank you.
In Howard Smith and Ampol, Howard Smith had made a takeover offer. The existing majority, Ampol and Bulkships, had said that they would reject that offer. The directors then issued shares to Howard Smith for the purpose of diluting Ampol and Bulkships, so that they could no longer block Howard Smith from purchasing further shares. For your note, that's at page 2267, line D. But I would like briefly to take you to page 2271, where Lord Wilberforce said at line C, the present case, by contrast to the case of Harlow and Tech, the present case on the evidence does not, on the findings of a trial judge, involve any considerations of management within the proper sphere for directors. The purpose found by the judge is simply and solely to dilute the majority voting power held by Ampol and Bulkships so as to enable a then majority of shareholders to sell their shares more advantageously. And I took you yesterday to the passage at line H and over the page, which says that it is the shareholders acting by majority who are entitled to decide whether to dispose of shares and at what price. So the mere fact that directors intend to alter the balance of power between shareholders is not sufficient to make their purpose improper. They need to have done so for the purpose of seeking to control some function which is allocated to shareholders, whether that be appointing directors, amending the Articles of Association, or deciding whether to sell shares and on what terms. Now, tech is another example of that. I don't have time to go
Could
to
you just
it.
repeat that test more slowly?
Sorry.
Write it down.
The mere fact that directors intend to alter the balance of power between shareholders is not sufficient to make their purpose improper. They need to have done so for the purpose of seeking to control some function which is allocated to shareholders, whether that be appointing directors, amending the Articles of Association, or deciding whether to sell shares and on what terms. And if I can just...
So they need to have done so in order to effect a power allocated to the shareholders rather than to the directors. But this was a power allocated to shareholders, wasn't it?
This was
This was to do with control. If you've got a 25% control in the company, you've got to complete the client due diligence. That's a shareholder control power, isn't it?
It's an obligation on the company, and that's why the problem of there not being any liability on the part of the shareholder. It becomes a management function. It is a management function because it's an issue. It's an obligation.
But it only arises as a result of having a 25% shareholding plus.
It does, but it is an operational matter of the company. It's not as we have canvassed before. It doesn't involve any obligation of the shareholder. It's a matter of at management level, the management having to address and deal with an operational matter, which happens to arise because a shareholder has a 25% or more interest.
But the whole as we've been through before, the whole point about the 25% threshold is it's the ability to block a special resolution. What the directors were doing was to ensure that Mr. Sinclair could not block a special resolution and hence was not regarded for CDD purposes as a person with significant control or any relevant control over the company.
Well, my lord, that happens to be a consequence of this, but the point was...
It's the whole point of it. It's not a consequence. It's the whole, as my Lord Legate put to you. I mean, it's the whole reason why the whole object sought to be achieved by this issue of shares.
Well, my lord, the argument, the way that it has been seen below and in the High Court and Court of Appeal it was a question of enabling the company, for example, to open bank accounts to deal with clients. It may, at a parallel, have the 25% issue may have a parallel issue. But the object for the share issue wasn't to enable, to prevent it being able to block a special resolution. It was for the company to provide services to clients and to deal with the crisis which Mr. Sinclair had created by his refusal to engage with their requests. This isn't a case like Punt, for example, where they have gone ahead and passed any special resolutions, or that was in any way in contemplation. It may be a consequence of the share issue, but it wasn't the purpose.
So, just to follow this through, if a board puts forward a special resolution to shareholders, and it knows that the minority shareholder who holds 49% of the shares doesn't agree with them and wants to block it, would block it, do you say it's okay or not okay for them to issue shares so as to dilute the minority below the 25% threshold?
So if what would the purpose be behind it to prevent?
Yeah, so the directors say, we think we know best about how to manage the affairs of the company, and we need for the benefit of the company to do X. That requires a special resolution. We know if we put it to the shareholders, the minority who hold more than 25% don't agree with us and will block it. But we're right. So we'll issue shares in order to dilute the minority below 25% so they can't block us. Is that okay or not? Is that okay or not okay?
Well, that wouldn't, and Punt has authority for that.
Right.
There is a possible exception which we mention in our written case, arising from the judgment of Sir Robert McGarry in Kane, where the issue was, and it's quoted at paragraph 43 of our written case, that he said he doubted it would never be a proper purpose for directors to issue shares purely for the purpose of maintaining themselves in office. And he gave an example of a case where preventing Company B from being reduced to impotence and beggary was the object, and the only means available for the directors is to retain control and issuing shares purely for the purpose of maintaining themselves, of ensuring that the company, an example of that given there, was that a competing company, A, acquires a large holding of shares in Company B with the object of running it down so as to lessen its competition. Now, that's a possible exception. We've set out why that's a potential line of authority. But that's the one exception, my lord, to the Punt position, responding to your question.
It's a fairly common part of commercial life that you buy up a competitor, not with a view to keep it going, but to close it down and get more market share as a result. And so what's being postulated is you issue the directors of the company that's been bought up, or majority stakes being bought up, issue shares to prevent that from occurring.
I
have difficulty with that, with that being appropriate. I mean, that's the commercial reality. That's the reason why people buy companies.
The way we summarise this at paragraph 46 of our written case, but it's, we say, on the basis of the authorities we summarise, that it's at least an open question whether, when directors issue shares in order to deter a takeover, and I emphasise this, my lord, in answer to your question, which would cause serious economic harm to a company.
Or should you say which in their view?
In their view, yes. My lord, indeed, that's an important addition. That might be a proper purpose. But I said, my lord, that's a sort of, in a way, a side issue in this appeal. It's just when I wanted to answer your lordship's question, I wanted to answer it a bit more fully. While we have the written case out, I wonder if we can go to pages 31 and 32, paragraph 31 and 32. And I just want to invite the court to read paragraphs 31 and 32. It's a brief summary of tech, which is another example of proper purpose and where the board can intervene.
So, is this right? Justice Berger thought that it might be okay to issue shares to dilute somebody to prevent a takeover if the directors believed on reasonable grounds that there would be substantial damage to the company's interest by a takeover. Is that correct?
Yes, my Lord. That wasn't the ground of his decision. The ground of his decision was what the directors well, the ground was as set out at paragraph 31 of our written case. He made a finding based upon what their purpose was. I'm not sure, my Lord, I'm going to have time to take us through tech in detail. Eclair's paragraph 16, Lord Sumption, explained that one of the commonest applications of the proper purpose rule in company law is to prevent the use of a director's powers for the purpose of influencing the outcome of a general meeting, because that offends against the constitutional distribution of powers. The board's powers are being used to influence a decision which a constitution assigns to the shareholders. And that was why the purpose was improper in Eclair's. Restriction notices had been issued which prevented shareholders from voting in order to influence or determine the fate of the resolutions before the AGM. I'm quoting from paragraph 25.4 of Lord Sumption's judgment, page 2670. Again, it is not merely the altering of the balance of power between shareholders that is the problem. It is doing so in order to influence the outcome of a general meeting. Tianrui is a case where Tianrui alleged that the board of the company had issued shares to enable certain of the existing shareholders to achieve voting control at a general meeting and to dilute Tianrui to under 25% so that it could no longer block special resolutions. You can see that from paragraph 16, page 2971. And the issue on appeal was whether Tianrui had standing to sue the company for the director's breach of the proper purpose rule. I just want to take court to paragraph 71 because my learned friend took you to it. It's at page 2983. And at paragraph 71, Lords Briggs and Hodge say, I'll just invite the court to read paragraph 71.
It seems to me that the difference between the cases that you're showing us and our case is it would be hard to say that the dilution to less than 25% in our case was merely incidental.
Yes, exactly.
That's the problem. All of these cases, the dilution to less than 25% or whatever the alteration is merely incidental to another proper purpose. Here, you've accepted that it was a necessary and intrinsic part of the purpose of these directors, for good reason and good faith and bona fides, to dilute Mr. Sinclair's shares to below 25% so that he wouldn't have to comply with those.
And indeed, their findings that you rely on, it was necessary to do this in order to achieve the end, but there was no other way to get there, or so they believed anyway.
Well, my lady, Mills is a case where it was for purpose of the directors specifically to dilute the preferential shareholders.
Justice Dixon, whose judgment I thought you put front and centre stage,
Says it was
on the last page of the judgment,
Yep.
uses the expression that it does no more than appreciation of one incidental consequence.
Yeah. 2/3 of the way down that last page.
Which page?
It's the last page of the judgment we were handed up.
188.
My Lord, I would suggest that what Mr. Justice Dixon was referring to was the consequence in terms of voting strength, but the issuing of the shares was directly.
Well, there were two asserted purposes. One was maintaining voting strength, and the other was protecting ordinary shareholders. Protecting ordinary shareholders was a proper purpose, as I understand it, whereas the other was not. But what Justice Dixon says is that first purpose wasn't really a purpose. It was an incidental consequence of the second proper purpose. Your problem is the dilution was not an incidental purpose or an ancillary effect. It was necessary and intrinsic. You said so yesterday.
Well, the protection to the ordinary shareholders in the case of Mills was involved a dilution of the preferential shareholders.
But that was an incidental consequence on the express finding of Justice Dixon.
Well, that was my lady. That was the actual purpose. The purpose was to improve their position as against the preferential shareholders on a winding up, and that's why the shares were issued. The subsidiary issue was maintaining a numerical majority of votes in the managing director and those likely to support him. But the actual direct consequence and aim was to improve the position of the ordinary shareholders as against in the event of a liquidation, as against the preferential shareholders. So it actually is a direct parallel, I would submit, where they actually were issued shares which did dilute the preferential shareholders, and the purpose was stated to be a proper one. The fact of majority voting control was a subsidiary, what was decided not to be the purpose, and that's when Mr. Justice Dixon is talking about the desire to maintain voting strength. He's talking about that second purpose. In other words, in order to secure the benefit, this is the wording of Mr. Justice Dixon, to ordinary shareholders of the greater part of reserves of profits in the event of liquidation, which was seen as the purpose, that necessarily involved the dilution of the shareholdings of the preferential shareholders. If they hadn't been diluted, then the ordinary shareholders would not have been entitled to anything more in terms of the profits in the event of a liquidation. So that it does have a permanent consequence as a result of the dilution. But the dilution itself, which was necessarily part of the, part of what was going on, wasn't seen as the purpose. So I submit that is parallel to this current case. And on Tian Rui, we're at paragraph 71. Now, it may be read to suggest that a board could issue shares, for example, for proper business purposes to new shareholders, altering the balance of power for existing shareholders, and that would be legitimate. If it was then gone on to say, well, actually, it wouldn't be permissible to deliberately alter the balance of power between shareholders so as to advance the power of one at the expense of the other, if that were the way that Power 71 was to be interpreted, we have two submissions on that. First of all, Lords Briggs and Hodge are not saying that any issue of shares to an existing shareholder which alters the balance of power between existing shareholders is impermissible. We know that would be wrong from Mills and Mills, as I've just tried to explain. What is being said here is it is impermissible where altering the balance of power is the director's purpose. See the words deliberately, the last sentence, deliberately aimed at altering a balance of power between shareholders so as to advance the power of one or one group at the expense of another.
Well, but the sentence before that says it's permissible if the power is exercised for the purposes for which the power was conferred and bona fide for the benefit of the company.
Yes, well, we say, in this case, the purpose was to meet the threat to the business posed by Mr. Sinclair's persistent non-cooperation. We say that's a proper business purpose, applying the wording of the second sentence of paragraph 71 of the judgment of Lord Briggs and Lord Hodge. This may have had the incidental effect of altering a balance of power and advancing Mr. Domaille over Mr. Sinclair, but it was not the purpose.
But the critical word is that you, in that second sentence, as my lady and my lords have been pointing out to you, is incidentally.
Yes. But what I say is that one has to look at the purpose as it was looked at in the case of Mills and Mills.
But that's saying if you incidentally deprive a shareholder of negative control as a consequence of doing something for proper business purposes, that may be okay. But it's not saying if you are depriving a shareholder of negative control as your immediate
deliberate aim,
that's okay. I mean, it's a given you've got to do it in what you genuinely believe to be the best interest of the company, because that's the separate test under 172 in English law or at common law, the fiduciary power. But that's not an answer to whether you're using the power for the purposes for which it's conferred.
The last sentence of paragraph 71 talks about excluding, for example, an allotment deliberately aimed at altering a balance of power between shareholders so as to advance the power of one at the expense of the other. That is not what was going on in this case.
Well, how do you say that when the whole purpose was to dilute the shareholding so as to reduce Mr. Sinclair's holding to below 25% and increase Mr. Domaille's to 75%? That's altering the balance of power of one at the expense of the other.
The purpose was the purpose was...
Well, the motivation may have been an operational bona fide one, but the purpose of this dilution was, and was expressed to be in the minutes, to dilute his shareholding to below 25%. And the corollary of that was to increase Mr. Domaille's to 75%. That's squarely within 71, isn't it?
Well, my lady, as I've tried to explain from Mills and Mills, altering a balance of power between shareholders is not necessarily a breach of the proper purposes rule.
Not necessarily. There must be a proper purpose.
You have to
be some.
You have to look at why it was being done.
I mean, it may have been capital raising and one can afford it and the other can't, and the consequence is that the the shareholding of the one is reduced because he can't afford to buy in. That would, I can understand that situation.
Well, in a situation where the business was in peril, that was the purpose here. We say is one has to look at the why, not just the effect. And we say you look at the why here, and it was the significant operational problems which Mr. Sinclair caused. And as Mills and Mills shows, it is not per se an infringement of the proper purposes rule to alter the balance of power between shareholders. One has to look at why they were doing it, and we say when one looks at the purpose, you look at why they're doing what they're doing. I don't think I can take that any further, my lady. Paragraph 71, to go back to Tian Rui, it provides a useful hypothetical. Imagine the directors had found a third party who was willing to be issued shares. In accordance with the second sentence of paragraph 71, that would have been perfectly legitimate.
Sorry, you lost me. Sorry, could you start again? Sorry.
Sorry, it's paragraph 71 of the joint judgment of Lord Briggs and Lord Hodge. Yeah. Let's say the directors had found a third party who was willing to be issued shares.
Willing to
buy
shares. Willing to buy shares. Right.
Yes. Yeah. Now, in accordance with second sentence of paragraph 71, that would have been perfectly legitimate, as the business purpose would have been neutralising a threat posed by Mr. Sinclair's non-cooperation. Now, why should the outcome be any different because the shares were issued to Mr. Domaille?
Well, for a start, the third party will be buying shares presumably at full value.
Well, that's the question of the detail of a price.
So, I mean, are you postulating that you're going to be selling shares to a third party at £9,000, or are you postulating that you're selling shares to a third party at full value?
My Lord, I was just postulating the idea of the board taking steps which would affect the balance of power.
Yeah, well, they certainly can do, and the shares can be sold, but the existing shareholders aren't worth their capital value. Their value of their shares isn't diminished if the third party injects capital into the company. They lose voting rights, so on, but they.
Well, the hypothetical I was raising actually wasn't on the facts a viable one. The Court of Appeal made a finding at paragraph 55.
Sorry, I was just... Yeah. You were postulating an example, and I was just trying to find out what example you were postulating.
I was postulating... I wasn't fleshing out the detail of it. I'm saying, in principle, if paragraph 71 applies to a third party third party, it should also apply to an existing shareholder. On the facts of this particular case, the Court of Appeal found at paragraph 55.4, page 1839, that no evidence has been drawn to our attention to suggest there was any realistic likelihood of attracting a third-party investor, particularly in light of the enforcement action by the GFSC at the time. My Lord, I was just trying to show that
just to be clear, I mean, to pick up Lord Stevens' question, was the evidence that you couldn't find any third-party investor to take shares on the same terms that Mr. Domaille took?
Well, the wording is there was no evidence to suggest any realistically likelihood of attracting a third-party investor, and the enforcement action by the GFSC was a serious deterrent. I can't, my Lord, I can't take you...
Investor, meaning somebody who's going to put real money into the company for shares as opposed to what actually happens. That's, I think, Lord Stevens' what underlies Lord Stevens' question.
Well, we're talking about anybody who would invest in the company in the light of the enforcement action that was arising.
Real money.
My Lord, I'm assuming that was being referred to. Now, in this case, we went on to now Proposition 4. The director's purpose in issuing shares to Mr Domaille was a proper one. Their purpose was found as a fact by the Royal Court and the Court of Appeal, and you can see that at paragraph 66 of the Court of Appeal's judgment. It was page 1842. And I quote paragraph 66, to the bottom of the page, bottom of the paragraph, second last sentence. The purpose was to obviate the need for Mr Sinclair's participation in the company's CDD obligations so as to avoid the operational difficulties caused to the business by his failure to cooperate in that regard.
And what do they mean in paragraph 63 then? The purpose specifically to reduce Mr Sinclair's shareholding.
Because of the operational difficulties the company was facing. But the finding in paragraph 66 was to obviate the need for his participation.
The trouble is, it seems to me, that once, if you were going to go down the line of saying you can discard a purpose as long as there's some legitimate further end in view, then you end up where the Court of Appeal did, with effectively collapsing the question into whether the purpose was to benefit the company as a whole, and relying on the test which was said in Howard Smith is not an appropriate test. That's where that train of reasoning leads you, I think.
Yeah. Well, my Lord, what we say is, the question actually is, are you doing it for a directorial reason or for a shareholder reason? Are you doing it in order to enable the articles to be changed, or the board to be, composition to be changed, or for some management reason? That's the distinction I've been trying to draw this morning.
So you can alter the balance of power as between shareholders for so long as you've got an operational or management reason for doing so. That's
Yes.
your case.
For example, in tech, choosing a business partner in order to develop a mine. In the case of Mills, it was to distribute capital. But it's a managerial function. Whereas allowing, specifically doing so in order to, for example, make sure the articles can be changed, to keep the directors in place or to remove the directors, that is not a managerial directorial function.
But I mean, a managerial directorial function on your case would be, we the directors think it's in the interest of the company to adopt this course of business conduct. If it requires a special resolution to authorise us to do it, and we know the minority would block that, it's okay to dilute them.
Well, here, the operational
I
function...
mean, that's the logic of your argument, isn't it? And isn't that contrary to all the authorities?
The operational function was to provide services to clients, which could only be done by complying with CDD. And in my submission, that is clearly a managerial function. And I'm conscious of time. I'm going to move on, I think, to price. I've identified the purpose here, and that there's no going behind paragraph 66 of the Court of Appeal judgment. If I now then move on to ground 2, which is price. Now, the respondent's case on the duties which apply to directors when determining the price at which shares are to be issued is simple. First, at common law, there is a duty to exercise the power to issue shares for a proper purpose. We've covered what that means. Second, there's also a duty, when issuing shares and setting the price in consideration, to act in good faith in a manner which the directors consider is in the best interests of the company. Importantly, this is a subjective duty. The question is not whether, viewed objectively by the court, the directors did act in the best interests of the company, but rather whether they subjectively believed that they were so acting.
Isn't there a duty of care as well? I mean, that was what the Court of Appeal was considering, whether they acted with due care.
Well, my Lord, on the particular issue we're looking at here is not, as I understood it, a question of duty of care, but whether there's a specific duty to get the best price obtainable when issuing shares.
Well, the Court of Appeal were addressing it as a question of duty of care, weren't they? In paragraph 72, they concluded there wasn't a breach of their duty of care. And earlier, under the terms of the share issue on paragraph 68 on 1843, Mr. Sinclair contended the directors were obliged to obtain a reasonable price in compliance with their duty to use reasonable skill and care. Paragraph 68. So I took part of the argument to be that although no doubt the directors have a very wide berth as to what acting reasonably involves, it wasn't consistent with their duty to adopt a completely irrational approach to valuation.
Well, the way we had understood the case being put by the appellant, it's paragraph 105 and 106 of their written case. Is that they challenged the page 1944. Challenged the third sentence of paragraph 72 of the Court of Appeal judgment. Once it's accepted, the power to allot shares is not necessarily confined to raising additional capital. It follows logically that the directors are not invariably required to obtain the best price they can, and that's not how the requirement on section 295 is expressed. And then paragraph 106 is what the case we understood we are here to meet. The board should hold that this is wrong under the general law. Section 295 is considered separately below. Even if the directors are not setting out to raise capital, the underlying value of the shares cannot simply fly out the window. The directors remain under a duty to take reasonable steps to obtain the best possible price for the company. We'd understood that the...
Well, one way of analysing that could be a facet of the duty to act with reasonable care, couldn't it?
Well, my Lord, we'd understood that this was a specific obligation imposed on directors, or thought to be imposed on directors, when they issue shares.
I mean, it may depend upon what you mean by best, but I understand that you would say directors are not under an absolute duty to obtain the maximum price, because there may be other good business reasons to issue shares for less than the maximum price that you could obtain in the market. And I gave yesterday an example. You might want to issue shares for less than the maximum price you could obtain in the market to employees, to incentivize them. And I could understand the argument that would say that that is okay. But where I struggle, like I think Lord Legos, is that at least in the example I've just given, the directors are acting either rationally or at least with due skill and care in reaching that view. I mean, do you say that if they subjectively believe that it's the price is the best price, that they can, it doesn't matter how irrationally or carelessly they form that view.
Well, my Lord, I wonder the best way to address this. I need to sort of take it in stages. Is that I'm faced with, first of all, a specific statutory case put under Section 295, and then I've got the common law duty.
Yeah.
Yeah.
I wonder if I could deal with the statutory duty first, then move to the common law duty. In particular, I would like to take the court to Saxon Woods, and then, my Lord, when I will then attempt to address the point your Lordship raised. Now, Section 295 is at page 2024 of the bundle.
Could you give me that page again?
2024.
2024.
Yes.
I think it was being suggested that this was, in interpreting this legislation, it was supposed to give extra protection to shareholders. That is, in addition to what the common law provided. Is that the right way of approaching this legislation?
Well, it imposes obligations on directors in order to ensure that they, well, perhaps what I best, can I just come to explain it? I will respond to it. Can I first of all explain what it is, and then say what it is, and then we'll come to the purpose of it. Before a company issues shares, this is page 2024 and 225, the Board of Directors must decide the consideration for which the shares will be issued and the terms on which they'll be issued, and resolve that, in its opinion, the consideration for and terms of the issue are fair and reasonable to the company. So it's designed to ensure that they turn their minds to the issue of price. Now, Mr. Sinclair suggests that this imposes an objective duty. Paragraph 1221 of his written case. He says the directors must in all cases obtain a proper price. He says the consideration must be right, paragraph 121. They must make an effort to secure adequate consideration for the shares, paragraph 123. Now, this is simply not what Section 295 says. It requires that the directors reach an opinion in the terms stated. It does not impose any other duty, for example, that the directors have objectively reasonable grounds for that opinion.
Well, even if you don't go that, if you accept it doesn't impose an objectively reasonable grounds, might it still not impose similar sort of constraint to, say, the exercise of contractual discretion that is, on the face of it, entirely a matter of somebody's opinion or belief, but it still has to be a belief that is not completely, opinion that is not completely whimsical and lacking in any reasonable basis?
Well, Lord, no. I would say that is not the case. If it goes to, for example, page 2028, you
say it can be a whimsical opinion, do you?
Oh, but it's not. It's a question of compliance. I'm saying what this section requires.
Well, can it be capricious and arbitrary?
Yeah, exactly.
Can they say we'll do it on the basis of hair colour? People with black hair will get twice as much as people with blonde hair.
Well, the obligation is it does resolve, and it's an opinion, a consideration of terms of reason. So, no, capricious would not cover it. No.
Capricious and arbitrary wouldn't be acceptable.
No.
Okay, so there is some objective.
But
whimsical.
But that in and of itself may be a breach of the good faith obligation of
You can be an honest but stupid person, or an honest and bigoted person.
Yes.
But if one goes to, let's say, section 3032, which is at page 2028, that concerns the authorisation procedure for making a distribution other than dividend. And it says there the Board of Directors may authorise a distribution if it's satisfied on reasonable grounds. The company will immediately after the distribution satisfy the solvency test. So, there is for them to be satisfied, they have to, it expressly says in the statute, they have to have reasonable grounds for doing so. All that Section 295 is doing is requiring the directors to turn their minds to the issue of terms in consideration and resolve that the terms in consideration are fair and reasonable to the company. It prevents directors from, in the language of Sunrise Radio, unthinkingly issuing shares at par. I'll come back to Sunrise Radio in a minute. But once they've turned their mind to it, it is a matter for their business judgment, and the court will not substitute its own business judgment. Now, a similar issue...
Unless it's arbitrary and capricious. Did you?
Well, to posit your example, then there hasn't been...
They've turned their minds on an arbitrary and capricious basis. Does the court have a role then?
The question is whether that will be compliant with the specific requirements of Section 295.
Yeah.
And it says it says decide the consideration and resolve in its opinion consideration is fair and reasonable, so it has to be its opinion.
Yeah, but my lady's question is an opinion which is capricious or arbitrary one that satisfies the test?
On a strict ruling of it, it has to form an opinion.
Well, are you inviting us to adopt an interpretation of the statute which is strict, or what we think that the legislature must have meant?
Well, my lord, the capriciousness may not specifically arise from the wording of the statute, but it might be a breach of a director's general duties.
Well, it's common practice in interpreting contracts and legislation often when something is subjectively framed, not to treat it as wholly subjective, but there are some bounds, such as arbitrary, capricious, and not a belief or opinion that any reasonable person could reasonably form, something like that. Kind of Wednesbury type of boundary in public law terms, but there's a similar concept in a lot of private law opinions and discretion.
A similar concept in relation to the exercise of a power under a lease that is going to be exercised reasonably.
Well, perhaps can I take the court to a potentially parallel example, which arose in the Sequana case, and if I could go to page 2696. It's the judgment of Mrs. Justice Rhodes, as she then was. Now, it concerns section 643 of the UK Companies Act 2006, which defines a solvency statement as a statement that the director has formed certain opinions, including that there is no ground on which a company could then be found unable to pay its debts. A solvency statement is required for reduction of capital unless the reduction is confirmed by the court, and that's clear from section 641 of the Act. Now, one of the many issues in this case was whether those provisions had been complied with. And if one goes to paragraph 331, Mrs. Justice Rhodes considered whether the provision required that the directors have reasonable grounds for the opinion they form. And she held that it did not. If one goes to paragraph 333, she says that if reasonable grounds were part of a requirement, one would expect to see it referred to in subsection 643(1) or 3. And that's the point that we make to this court. If it was a requirement that the terms in consideration be objectively fair and reasonable, one would expect to see that on the face of section 295.
And you make the contrast with section 303.
Yes.
Well, I don't think any of us, well, speaking for myself, is suggesting a reasonable grounds test.
Yes.
But we are wondering whether there is, at the extremities, some boundary that would enable the court to look at it and say this is wholly irrational or perverse or capricious or arbitrary. That's what we're putting to you.
Can I just, whilst you're pondering that, because it's related, there is a way which I've certainly seen it argued before, which is that the test is, as you would say, purely subjective. What did the director actually believe? Sometimes it's said genuinely believed, but I'm not sure that adds anything, just what did they believe? But that in deciding what they actually believed, the more irrational, unreasonable, capricious or arbitrary it is, the less likely it is as a matter of evidence that the court would accept that it's what they genuinely believed. And it's therefore an evidential. I think you get some suggestion of that from Regent Crest and Cohen. But that's, I mean, I'm not saying that's right, but I think there is at least some support for that approach.
Yeah, my lord,
That's always open that to infer from the irrationality they didn't actually believe it. But here you can rely on the fact you have findings in your favour that they did believe,
Yes.
that they did honestly believe it. So.
yes, my lord, I would accept your lordship's proposition. In this case, we would say there is no basis to say that the directors acted in an arbitrary and capricious way. So whilst that...
But I think we're looking to actually understand what the section means.
Yes.
So the answer to my Lady Simler's question is
Yes.
what?
is that there's no reasonableness requirement.
Oh, yes, that's okay.
There could be scope for some arbitrary or capricious. How one defines it and how it actually would work in practice, especially where you're dealing with, for example, in this section, you've got people who will want to see whether there's been compliance, third parties who weren't part of the decision-making process, who would want to know, has there been compliance?
Well, does
with
it
the section?
include an irrational opinion?
So we no, that involves a reasonable.
It's not reasonableness, it's a Wednesbury test.
Well, how
no
would
reasonable person could possibly come to this conclusion.
How would third parties?
Sorry.
Third parties would see the minutes, for example, of a board meeting. It says that they've complied with it.
So
It would create a lot of uncertainty.
Just let me understand. You submit that the opinion they can form can be an irrational opinion.
Well, I'm not just saying they can. I'm saying, they can be. We're looking here at what statutory requirements are. If it doesn't arise here. If and to the extent that one has to, there's a rationality requirement. That may arise in some extreme case.
So you accept a rationality requirement?
Well, I accept it could arise. It could be seen to be a part of the obligation. I don't think there's been any case law where this has been explored in this context. So we're looking at it hypothetically here.
But to pick up Lord Stevens' first question to you, the legislature has decided here to supplement whatever protection there is for shareholders by putting in place section 295, sorry. Could that not be to impose to some extent restrictions on what otherwise it might be thought to be a purely subjective test at common law?
Well, problem is, my lord, all I can say, my lord, is that there was we see the wording. We also see the wording that it used to have and which it no longer has. And that's the point which my learned friend, in his written case, focuses a lot on the New Zealand provision, which required that directors resolve that, in its opinion, the consideration for and terms of the issue are fair and reasonable to the company, and his extra words, and to all existing shareholders. Those were words which were also in section 295, and they were removed by section 90 of the Companies Guernsey Law 2008 Amendment Ordinance 2015. That's at page 2035 of the bundle. And it was express reason for that was that the director should act in the best interests of the company even if it's not in the best interests of an individual member. And for billet d'état from the Commerce and Employment Department of the Chief Minister, it's page 3153. So if we're looking at what the purpose of section 295 is...
I'm not sure that answers the questions you've been looking at. Yes. I mean, it might, for example, ensure that directors can issue employee shares at a discounted price without fear of criticism from the existing shareholders that their economic interests were being adversely affected. And that may well be what that was aimed at. But I don't think it answers the question. Does their judgment have to be, is it enough that their judgment is the one that they subjectively hold, irrespective of whether it is capricious, arbitrary, irrational, or careless? And that's the question that you're actually dealing with. I'm not sure that amendment really bears upon it.
Yeah. Well, I don't know if I can assist further. We assist in a case where there is any question of these extreme situations arising. So I don't know how far I can assist in this hypothetical.
Well, I just wonder, because Lord Wright in Larry at page 2153 sets out what the common law is, and that is, it is true that it is within their powers, under the Companies Act, to issue it at par, even in such a case, but the duty to the company is not to do so unless for good reason. Okay? And what you're postulating this section to do is you don't have to have a good reason at all.
Well, my Lord, first of all, we don't accept that Lord Wright's dictum represents the law. And I'll come to that as part of my argument on the common law.
Okay.
Secondly, I say the starting point is the plain words of section 295. And if there's some extreme example which might be positive, which might arise in some other case in which the edges of section 295 and compliance with it are explored, then that would be an opportunity to explore where somebody is deluded, someone extremely ill.
It might be suggested that it's totally and utterly irrational to issue these shares at the amount that they wish it for.
They might as well pick a number out of the telephone directory.
There was
Has taken the number on these accounts.
Relationship with reality.
Well, we have the rationale given by the board for why they took this approach. It may be that this wouldn't be an approach which would commend itself to the court, but
it doesn't make sense, their explanation. That's the problem that we've got, I think, that you have. The question is whether you can surmount the very low bar of saying that there's some sort of coherent idea that one could think that they were relying on. But I mean, their treatment of the numbers in the accounts as meaningful seems to be completely devoid of any rational basis.
Well, can we perhaps go to the... Can we go to a minute, my Lord? Because that does record their thinking at that time. It's page 1372, paragraph 5.14. It records that the directors did carefully consider price. They considered valuation of the shares in view of the uncertainty facing the company, given the enforcement action by the GFSC. The directors consider that any efforts to value the company would be problematic and open to challenge. And if you go back to paragraph 510,
Well, one of your clients had just valued it at £7 million.
I'm not sure about the word therefore in the next sentence.
Yes. That's the problem.
Can you help us in relation to that?
sorry.
Sorry, you deal with one point at a time.
Yeah.
Well, and if we go back to paragraph 510, they note that he's been approached a number of times to agree a valuation to enable him to sell his shares to majority shareholder, and he's repeatedly failed to engage in the process. And then, so just give me 1 minute.
The question is, how could they think that the balance sheet value was less problematic and open to challenge?
Particularly when the sums in the bank for the two subsidiaries was greater than this number.
And in fact, just to add to the chorus, if I may, the £260,002 wasn't actually valuation at all. It was just its cost.
Can we start perhaps with the KPMG valuation, which has been referred to. Now, the Court of Appeal, the valuation is dated March 2020, 18 months before the share issue in August 2021.
Sorry.
Now, the Court of Appeal found, this is divider, so this is page 1826, paragraph 11, that the KPMG valuation was a reliable indicative value as at that date, in other words, March 2020. But that's not just an arid point. If we go to the valuation, page 1258.
Sorry, we're going to page...
1258.
Thank you.
This is a KPMG valuation, the draft valuation. And when it goes to page 8 of valuation, page 1258, second, right-hand column, valuation approach, it says this. The valuation has been performed on the basis that Artemis TL's regulatory license is not revoked by the GFSC as a result of their investigation, and any resulting public notice does not result in material client or staff losses. Irrespective of outcome, the group will likely have to incur further significant one-off remediation costs, which would be difficult to identify and quantify at this stage. Any such one-off remediation costs, once established, would need to be deducted from the EV, as it essentially represents a contingent liability.
So that's the equity value, is it?
Sorry?
The EV, equity value.
Equity
is it?
value, yes.
Yeah.
So there was an uncertainty point which was highlighted.
Well, even if they'd taken a sort of net asset value, or the sort of figure you might get on a winding up, it would have been a substantial amount, wouldn't it? It wouldn't have been a nugatory sum like the sum that they alighted upon.
Yeah. Well, they wouldn't know what to deduct for the potential issues which have been highlighted at 1258. You've got this.
Well, they could
probably
exercise a judgment then, and as long as it was reasonable, they couldn't really be criticised.
Well, there's this one-off remediation costs, and it could also be as a contingent liability, and there may also be other losses. So it's not simply a question of seeing how much is at the bank.
Well, the problem was they didn't engage in the process at all. If they had, it'd be very hard to second-guess their judgment.
My Lord, I've taken you to the minutes. I've taken you to paragraph 5.14, which refers to the uncertainty facing a company in relation to the enforcement action by the GFSC, which is specifically referred to in paragraph 5.14.
Well, if we saw in the minutes, we went through, we considered all these, and we considered that the company was actually worth nothing or only a token amount. So we thought the shares should be issued for a token amount. then they might at least have had something to go on. They didn't take that approach.
Well, my Lord, all I can do, I take you to the minutes, paragraph 5.14. One can also see that they went on, they also considered Mr. Sinclair's own interests as a minority shareholder. You'll see that at paragraph 5.6. He noted in the end, the dividend was declared, the company sold it, would be a disadvantage to a minority shareholder. They dealt with that concern, was to reflect on the company's historic practice as to the declaration of dividends, none in the last 3 years.
I know their findings of good faith that we can't go behind, but the reason given is so bad that it really makes one wonder whether this is all that meets the eye, these minutes.
Well, my Lord, that would involve this court becoming a finder of fact as to the...
Yeah, I know, we can't go that far, but we can at least say that there was no rational basis for their conclusion.
Well, my Lord, that would involve a finding which, of irrationality, which neither the jurats, who had the benefit of a 5-day trial, or the Court of Appeal came to.
Yes, it would.
So we'd have this court making a finding of irrationality based...
It's not a factual matter, it's a matter of evaluation of the reason given, isn't it? And it's utterly unsupportable. I mean, if you've got if you feel you can support it, this statement that it was the objective valuation of the company, then give us the reasons that on which we should say it wasn't irrational.
Well, my Lord, this is not a case like, for example, Sunrise Radio, where the rights issue offer was priced at par unthinkingly. No other price was considered, par was considered.
Well, it is unthinking.
Perversely.
Perversely. But there, as my Lord Lloyd Jones asked you a moment ago, what does the therefore mean? There are all sorts of difficulties in valuing the company. Therefore,
we'll take an even worse approach, a far worse approach.
I mean, it's unthinking. Where is the analysis that explains why that is a rational basis for valuing it?
Well, one has to appreciate that this is Mr. Domaille also need to be involved in this. Obviously, he wasn't involved in this decision,
no,
but he had to agree to buy the shares.
Well, I'm sure he didn't have much to lose much sleep over that choice, given that he was being given an enormous chunk of the company.
Well,
for free.
The difficulty is, my Lord, what we're engaged in at the moment is a minute analysis of these minutes, as if they were statute.
Not very minute, just subjecting them to a very low test of logical coherence or intelligibility.
And really what we're asking you, Mr. Lightman, is just to help us. What is the analysis that shows that this was not irrational and not arbitrary? And
it could have been improved on if the minutes are said not to be sufficient at the trial, if a case was advanced to justify.
Well, they needed Mr. Domaille to accept the shares in order to deal with this very serious operation.
Well, there wasn't going to be a problem with that if they were going to if he was only going to have to pay 0.01 of a pence and then get it all as a loan in any event. So that's with respect, that's...
Is a suggestion that if he'd had to pay twice that much, he might have balked at it, or get lent twice that much by the company?
I can't take this any further. I can only take you on basis of the material.
I mean, saying anyway that the company wasn't worth anything potentially because of these risks flies in the face of the kind of correspondence that was going around in which large sums of money were being talked about throughout.
It also flies
It
in the
doesn't
face
so much matter how exactly what they were.
of economic reality.
Yeah.
You know, lots of companies are bought and sold, and they've got all sorts of question marks over their future. The idea that they're incapable of being valued is risible.
Well, my lords, I'm going to now, in view of the limited time I have, go back to the law on the common law duty. I want to start with Saxon Woods, which should have been
It has been,
uploaded to the
yes.
portal, and we have hard copies as well.
We do.
And if one goes to paragraph 29, it's a judgment of Lord Briggs, with whom Lord Sales, Lord Hamblin, Lord Burrows and Lady Rose agreed. If we go to paragraph 29, Lord Briggs referred to the principle that in managing the affairs of a company, it is for directors to exercise their business judgment, with which a court will not interfere if the directors act bona fide. He describes this principle as being of long standing. At paragraph 30, he goes on to explain that this power applies to all aspects of the general powers of management of a company's affairs by the board. The obvious intention of the framers of the company's constitution was that it is upon the board of directors and no one else that the exercise of business judgment about the management of the company's affairs has been conferred. Paragraph 31, he states that the court will not interfere with a subjective view of the directors, mainly because it forms a different objective view of what is really in the best interests of the company. And at paragraph 54, he refers to the great importance of the principle that the court should respect the business judgment of directors as to the best way to promote the best interests of the company. At 57, he says the board's business judgment was, I quote, the prime motivational force in the company's success, hence why it is respected by the courts.
So what was that last paragraph?
Paragraph 57.
Thank you.
Do you mind showing the court 55, just so I don't have to show them?
Yeah, and 55. I invite the court to read paragraph 55, as my learned friend has requested. Yes, of course, in that particular case, rather extreme case, it says in covertly seeking to implement his own dissenting view as to the company's best interests in the face of, and so as to subvert the contrary view resolved on by the board. That was the question that arose in that rather extreme case. Now, Mr. Sinclair contends, in addition to the duties to resolve, as Section 295 requires, there's an addition to the duty to act for a proper purpose, to act in good faith, the directors also owe a further specific duty to take reasonable steps to obtain the best price possible when issuing shares. That's paragraph 105 and 106 of his written case. It was put in these rather absolute terms in his written case. In the course of oral argument yesterday, that argument morphed into a duty that the directors obtain the best price possible unless there is good reason for not doing so. It was submitted by my learned friend that whether there's a good reason is a matter to be judged objectively by the court. It's not a matter for the business judgment of directors. In no other area of company law does the court substitute its view of what is good for the company for the view of management honestly arrived at. Formulating the duty in this way is simply unworkable when one considers the wide variety of circumstances in which directors issue shares. Sometimes they'll do so to raise capital. If that is the purpose, then whether to issue shares at the best possible price is a finely grained judgment call. The company might obtain a higher subscription price and therefore greater capital overall by issuing at a lower price. That has been recognised in numerous authorities, including those cited by Mr. Sinclair. We don't need to turn them up, but they include Shearer, decision of Walton, J, and Petty, is it really being suggested that the court will start interrogating whether the directors were right to think that if they issued shares at 60 pence per share rather than the higher market value of 80 pence per share, they would get a higher level of take-up, benefiting the company as a whole? As was recognised yesterday, sometimes directors will issue shares to incentivise employees. And that's the point I think Lord Stevens in particular mentioned. In such cases, shares are usually issued at par or otherwise at a significant discount to market value. This has been an established practice for almost 200 years. See the judgment of Viscount Morn at paragraph 660 of Lowry, which is page 2134. Is the court really going to start interrogating whether it really benefited the company for employees to get shares essentially for free? Sometimes directors will issue shares as part of selecting a business partner. In tech, which was cited with approval in Howard Smith and referred to in our written case of paragraph 31, the directors issued shares to Canex at a lower price than tech had offered because they thought tech would be a better business partner for the development of the mine. Is the court really going to go into which of tech or Canex would be better at developing the mine, and whether Canex was so much better than tech as to justify the lower price? Directors need to be free to make these finely grained judgment calls, not straitjacketed by inflexible rules that they must obtain the highest price. Giving directors the freedom to exercise business judgment is how companies succeed, as Lord Briggs recognised in Saxon Woods. The Court of Appeal in this case was therefore entirely right to say at paragraph 72 of its judgment that directors are not invariably required to obtain the best price they can, contrary to the submission at paragraph 105 of Mr. Sinclair's written case that this was an error. Now, turning to the authorities, Mr. Sinclair has only been able to identify a few authorities which he says support his contention. The directors are under a duty to take reasonable steps to obtain the best price when issuing shares. On analysis, these authorities do not support this proposition at all. First is a passage from a dissenting speech of Lord Wright in Lowry. This is a passage at page 2153 that the court was taken to. Okay. So if we go to page 2153, now, if a share stands at a premium, this is what was said, the directors prima facie owe a duty to the company to obtain for it the full value which they are able to get, unless there's a good reason not to do so. I'd just like to make a few points about this. First of all, Lowry was not a case about unfair prejudice or breach of directors' duties at all. You can see from the headnote, which is at page 2122, that the company had allotted shares to its staff members at face value, and the issue was whether the company could, when computing its profits for income tax purposes, deduct the premium that it would have received had it issued the shares on the open market. Viscount Caldecott, Lord Chancellor, Viscount Morn, Lord Russell were in the majority in holding they could not. Lord Wright and Lord Roma dissented. In their speeches, Viscount Caldecott, Viscount Morn, and Lord Russell did not refer with approval to the prima facie duty point that Lord Wright made, or make the point themselves. In fact, all of them were at pains to emphasise that the company was entitled to issue shares at par. For your note, the references are Viscount Caldecott, page 2130, Viscount Morn, 2143, Lord Russell, 2143. Lord Roma, albeit also dissenting, stated, and this is page 2166, the directors may, if they think fit, and if they act in good faith, issue the shares at par. So Lord Wright's dictum is at best a lone voice on this point. It does not carry the imprimatur of the House of Lords. Lord Wright doesn't cite any authority in support of the prima facie duty to obtain best price proposition. What is the source of this alleged duty to obtain full price? But depending on what Lord Wright means by good reason, it may not matter whether this passage from his judgment is regarded as good law or not. If he accepts that if the directors in good faith consider there's a good reason not to seek to obtain the best price possible, then that is permissible. If that's indeed his position, then it's not objectionable. It's my learned friend's spin on this that there must objectively be good reason, which is problematic. If we go to page 2161, from the judgment of Lord Wright, he says, about 2/3 of the way down, it is true that the directors would not be breaking any provision of the Companies Act if they allotted shares at par instead of realising their market value. They might do so for some legitimate reason, and he sets out some. So Lord Wright acknowledges that the duty to obtain the best price is not absolute. He doesn't say whether the legitimacy of the reason is a matter for the business judgment of the directors or is a matter for the judgment of the court. But the latter is highly unlikely. It would cut across the long-standing principle that in managing the affairs of a company, it is for directors to exercise their business judgment, with which the court will not interfere if the directors act bona fide in what they consider to be the best interests of the company. And it gets very difficult for the court to assess what is and what is not a good or legitimate reason, as I was saying previously. So if the rule is obtain the best price unless the directors acting in good faith judge that there is a good reason not to seek to obtain the best price, then there may not be very much clear water, after all, between the Respondents' case on this appeal and Lord Wright's dictum. In both cases, the price is a matter for the business judgment of directors. It is just that Lord Wright considers there is a rebuttable presumption that directors should obtain the best price.
How does the business judgment rule interrelate with the duty of care that directors owe? What's the relationship between those two duties, between the rule and that duty?
Well, when the court evaluates whether there's been a breach, it has to have regard to its respecting the business judgment of directors. And so there's a margin of appreciation.
Yes, but it's not altogether ousts the consideration of reasonable care. It just gives a wide ambit. Is that right?
Yes, my lord.
Thank you.
Now, Mr. Sinclair then cites Mayor and Scottish Cooperative Wholesale Society. This can be dealt with very shortly. Mr. Sinclair seeks to rely upon a dictum of Lord Denning at page 2223. The duty of the three directors to the textile company was to get the best possible price for any new issue of shares. As we explain at paragraph 61 of our written case, this is a passing comment, not part of the ratio of the case, nor is it a point made by in any of the other speeches of the law lords. Lord Denning was referring to an earlier instance in the history of the parties' relationship where the society had been considering the issue of further shares, and he commented on that duty. The comment about the duty of the directors in that instance would have been to get the best price possible. In fact, the shares were never issued, and the proceedings did not concern a share issue at all. Petty, and I'm not going to have time, unfortunately, to take you to it. It's at page 2335 and onwards. It again, at 2342, paragraph 21, cites Lord Wright's dictum without referring to the fact that it was a dissent. And it was in support of the proposition, paragraph 13 of the judgment, page 2339, that in issuing new shares, directors are under a duty to issue them at the highest premium that could reasonably be achieved unless there was a good reason in the commercial interest of the company for issuing shares at a materially lower price. Again, our case is that even if that is correct, where there is a good reason is a matter for the business judgment of the directors with which a court will not interfere.
Well,
Now Petty was decided...
I was just wondering whether a good reason involves some rational thought process leading to a reason. I mean, the point you make is really no court should be interfering with the subjective running of a company. That's a matter for the directors, win or fail. But a good reason ordinarily means some rational reason, some rational thought process.
Let's give an example rather than absolute. Let's say if the directors form a view that because of the intrinsic uncertainty of the Guernsey possible intervention in Guernsey, they can't get an accurate valuation of the company. Then it is rational we'd say it would be rational to rely upon the statements that they did rely upon. Now,
I wasn't really looking at the facts of this particular case. I was more concerned with whether you accept as a proposition that good reason, if that's the right test, would involve, even though subjective, would involve a rational thought process on the part of the directors. And tell me if I'm wrong.
Well, it seems to be, I would have thought it was implicit in your acceptance that there's an outer bound to the ambit of the business judgment, which is defined by reasonable care.
Well, I suppose it's a question of how far the court will reverse, because it won't go into the merits.
No.
Say, well, I personally think, this was a wrong decision, this was a bad decision, this wasn't a clever decision. And so we're talking here about, outside of that, is there, I guess, any basic rationality to it in a very low level?
Yes.
Mr. Lightman, we're going to have to
Yes.
draw this matter to a close shortly.
Yes, well I'm going to try and do that. Let me quickly say Petty was decided on the basis that the directors had not advanced any reason for issuing shares at par. References to that, para 11, 14 and 31 of the judgment. Now, Sunrise Radio, do I have 5 minutes so I can...
Yes, I think.
You don't.
Yes, I think he does have 5 minutes.
I'm sorry, I was just being passed a note. You have 5 minutes.
Yes. Okay. Yes. Well, if I have 5 minutes, I'll use it as well as I can. Sunrise Radio. I won't take you to it. Paragraph 95, page 2490. Where it's known that a minority shareholder will not subscribe, the directors must turn their minds to price. They should not unthinkingly issue shares at par, but consider the matter fairly in the interest of all groups of shareholders. But at paragraph 96, he goes on to say, once they've done that, the decision will remain for the commercial judgment of the directors. The board's deliberation should be carefully minuted as it was here. There has to be a margin of appreciation to directors in the exercise. It would be wrong, as we say at paragraph 97 of our written case, to apply to company directors the same stringency that's applied to trustees when deciding whether they've taken all relevant considerations into account. So Sunrise Radio is not authority for a proposition that directors have a duty to obtain the best price. It's authority for a proposition that directors must properly consider price, which we say they did here. And indeed, the reasoning in this case demonstrates how wrong or unworkable it would be to impose a straitjacket duty to always obtain the best price. Look at paragraph 76 of Sunrise Radio, page 2484. Judge Pearl recognised that if shares were offered at market price, i.e. pro rata to the value of the company as a whole, that will appear unfair to minority shareholders wishing to subscribe unless they have an undiscounted exit route under the articles. On this appeal, Mr Sinclair does not suggest in setting a price the directors acted otherwise than in good faith in the manner they considered would advance the interests of the company. And it wouldn't be open to him to do so in light of the findings as described at paragraph 42.1 of the Court of Appeal's judgment, page 1834, that the Royal Court found that the share allotment was made in good faith by the directors, what they believed to be in the best interests of the company. Now, it's a marked contrast with Petty, where the respondents did not advance any reason, and Sunrise Radio, where the rights issue offer was priced at par unthinkingly. To the extent that Mr Sinclair is now seeking to run a case that directors had a duty to take all relevant considerations into account when setting a price, and failed to do so, or take particular considerations into account, it's not open to do so. So we set it out in our written case. He didn't plead it. As a result, the jurats didn't make any findings as to which factors the directors did and didn't take into account, whether they would have acted differently had they taken into account. The only question they were asked on this was the value, question 11, page 633, was the valuation determined for the issue of new shares for the dilution fair and reasonable? And all I would, in conclusion, I would say that, as I pointed out, if the court were to determine that the appeal should be allowed, I did refer to this yesterday, we would say that the issue of remedy should be remitted back to the Royal Court. There was some discussion about, well, if it's a breach of directors' duties, the court should set aside the share issue. It's very commonplace in unfair prejudice petitions for a party to allege breach of directors' duties, and to that to be found. That doesn't mean that the court then automatically sets aside anything that's happened in breach of duty. It then comes down to the court then being empowered to make order such remedy as it thinks fit.
If we found that this share issue was done for improper purposes and without any rational basis, it was priced without any rational basis and breached Section 295, given that the two parties have both indicated that they would wish to see Mr. Sinclair bought out but just haven't agreed upon the price, why wouldn't it be an appropriate thing for this board to do to cut the Gordian knot and simply order a buyout at an independent valuation and remit to the Royal Court any questions as to the precise parameters?
Well, such as what, data valuation, minority discount, and issues like that.
Yeah.
Yes. Well, my lord, it would be. I'm answering a question, my lord. What we would say would be appropriate for the Royal Court to exercise its discretion in the round. For example, but my lord, if your court were minded to make a share purchase order, it would, I submit, be on the basis that the terms of any such purchase, data valuation, minority discount, methodology of valuation, uncertainty discount, which is one of the other points, all of those issues which would need to be determined by the Royal Court rather than this court. I think it's common ground, paragraph 132 of the appellant's written case, that is the approach to be taken.
Thank you. Thank you, Mr. Lightman. We're grateful. Mr. Grant.
Thank you very much, my lords, my lady. Mr. Sinclair, who is in this court with his wife, is a man now aged 77 years. He's a man in retirement. This litigation and the dilution of the shares that led to it has, I think the court will no doubt appreciate, cast a very dark shadow over the last 5 years of his life, years that he hoped would be years where he could enjoy his retirement rather than be locked in Jarndycean litigation, as my Lord Stevens so aptly described it. And this court, of course, also knows that Mr. Sinclair is not a well man. I
think we're more interested in reply than the summation.
I'm coming,
Mr. Grant.
My lord. There's method in this, which is that we heard yesterday from my learned friend a number of submissions about what this court should do in the event that it were to allow this appeal. And my learned friend, Mr. Lightman, made sustained submissions, no doubt on instructions, that this court should, if it were to allow the appeal, simply punt off to the Royal Court all matters, including remedy as a whole, so that remedy...
Because no findings had been made on critical aspects, he said.
Well, he pointed to various questions that had been posed, which the jurats had intentionally not answered, and your ladyship is entirely right. If that was the outcome, and I'm trying to look forward here, if that was the outcome, this court would be simply imposing upon the Royal Court, and indeed upon the litigants to it, a yet further round of litigation. Who knows how many years that would last. The critical point here, in my respectful submission, is that if this court allows the appeal, it should be obvious that the outcome of that allowance will be a share buyout order. Now, I accept.
Well, why is that obvious? Why isn't it restoring the shares?
Well, I'll tell you why it's obvious. Because everyone accepts that there should be a passing of the ways between Mr. Sinclair and Mr. Domaille. My lady, can I just remind you, your ladyship, that there was an offer made just prior to the trial by the respondents to purchase Mr. Sinclair's shares at a particular price. There was a counteroffer, and sadly, no agreement was reached. Ms. Guillou, when asked about this in cross-examination, and I can give you the citation, it's page 332 of the bundle, the question posed by Advocate Brecken, who sits behind me, said, "Do you accept, Ms. Guillou, that there needs to be a clean break between Mr. Sinclair and Artemis Holdings?" Answer, I can see that would be beneficial to all parties, and I respectfully agree with Ms. Guillou's answer. I also respectfully agree with the premise of the offer that was made by the respondents on the 19th of April 2024 prior to this to the trial starting. So what I suggest to this court, so as to avoid the Jarndyce and Jarndyce quality of this litigation continuing for many more years to come, knowing the circumstances of my client who sits behind me, the court should say, given on the assumption that I prevail on my primary points, then there is no need to remit the question of remedy at large to the Royal Court. I accept that questions of data valuation and minority discount are not ones that this court can make any rulings on. I do accept that. So there has to be some further litigation, if the matter, of course, can't be agreed. And I would very much hope that if a judgment emerges from this court, which sets out clearly the rights and wrongs, so to speak, of the parties, then the parties will show.
Just to be clear, if this court was to say, yes, like many judges before in the cases of this kind, there has to be a parting of the ways, the parties accept that, it's just a question of how much. A buyout order is appropriate. Just running through the issues, it would be on the footing that the share issue was invalid, because that's what we would have found.
It would be on the basis that the shares were... Sorry, I'm sorry to interrupt you, my lord.
It would be therefore on the basis that Mr. Sinclair had his original 40, whatever it is, percent shareholding. The discount would be one that the valuers could determine, or if not, the court decide. The data valuation would be on the basis that the issue of shares was unfairly prejudicial, and generally speaking, that gives the victim of the unfair prejudice the option either to elect for the event that caused the unfair prejudice or the date of the valuation. What else is there? Is it that the only thing I can think of that might have some other bearing is that it might be said that Mr. Sinclair's conduct has caused some uncertainty to the value of the company. Is that a question which we should or shouldn't remit on this hypothesis?
It's not, for these reasons. A, that was never a pleaded matter of defence, and B, it's never been raised in any aspect of the appellate process. There is not, can I just say this, there was reference by my learned friend yesterday to a particular passage from Mr. Hollington's book, page 3136 to 3138. I'm not going to take the court to it now in view of the time. If one reads Mr. Hollington's passages, it is clear that the juridical foundation for the line of authority that Mr. Hollington identifies is the so-called clean hands doctrine. That is clear from the quotation of the necessary relationship, which of course is precisely the words used by Chief Baronair in Dering and Lord Winchelsea from the 1790s. That is known to be a very narrow doctrine, the clean hands doctrine.
It's not the basis on which the courts have previously done it.
Well, that's Mr. Hollington suggests.
Well, Mr. Hollington may suggest that. Yeah. I make another suggestion, which is based upon some authority, which is that I think it's London School of Electronics, the case I mentioned yesterday.
Yes, quite.
Where the court simply said there may be circumstances in which the conduct complained of is prejudicial but not unfair, and the reason that it's not unfair is because of the conduct of the petitioner. And the court, in that case, unless my memory has failed me, didn't base the decision on clean hands.
As I recall that case, and I have to confess that I haven't studied it recently, although I have in the past, I think my learned friend Mr. Loveday has recently studied it, there was no finding that a remedy should be withheld from the petitioner in that case. And let me say this,
yes,
if I may.
The juridical basis for that is the case, I think, which acknowledges that that is that the statute has two elements. One is prejudice, the other is unfairness, and that the conduct of the petitioner could mean that even the prejudice that he suffered is not unfair to him. Now, that wasn't based, as I recall, unless you can tell me, and my memory may have failed me, but I don't think the juridical basis for that analysis was the equitable doctrine of clean hands in the way that Mr. Hollington suggests.
My Lord, I cannot precisely assist you on that question because I've not gone back to it. And the reason I can't assist you on it, and of course I would have gone back to it, is that it has not been suggested at any stage, so far as I'm aware, by the respondents, that some particular moral fault on the part of the petitioner in this case should in and of itself drive him from, to use the old phrase, the judgment seat. And there's certainly no plea to that effect, and there's no plea of unclean hands, while recognising, my Lord, that you say that that there may be a wider juridical foundation. I think that my answers were in the context of your Lordship asking whether there should be some further point remitted back to the Royal Court. Answer, I don't think it's been suggested by my learned friend that some further point of assessment of moral fault and how that affects the outcome is a separate point that is deserved.
I think I asked him the questions yesterday, and I thought that's what he was. I asked him quite directly, are you trying to preserve the right to submit to the Royal Court that there should be no relief because the conduct of Mr. Sinclair rendered any prejudice which he suffered not unfair, and he didn't give, I don't recall him giving me an actual answer to that.
Yes, well,
he certainly didn't, as I recall it, or certainly as my perception, he didn't close out that option.
Well, I may have misunderstood my learned friend's answer, but I don't think I can assist any further on that. Could I just raise another very narrow point, just to assist the court? I think my Lord Snowden posed the question. Surely the answer back in the autumn of 2021, after the dilution, was for the parties to agree to an independent valuation. And if I may say so, a profoundly sensible suggestion on the part of my Lord. The answer actually on going back over the correspondence is that that's precisely the position that Mr. Sinclair adopted. I'm not going to take the court to the relevant pages seriatim, but if I could just ask the court to note the letters sent on behalf of Mr. Sinclair by his advocates at pages 1486, 1491, 1496, 1500, 1505, 1515 and 1519. It's a turgid list, but it's an extremely important one because Mr. Sinclair, via his advocates, was persistently saying to the respondents, look here, surely the answer here, to cut the Gordian knot, to use Lord Stevens and indeed Lord Snowdon's evocative phrase, is to get an independent valuer to sort it all out so we can go our separate ways. The response that came back from the respondents was a profound negative, and to simply stand upon the KPMG report, which Mr Domaille himself had commissioned, and where it wasn't clear in nature of the instructions that were given. We don't need to worry about precisely what instructions were given. That was the respondents' response to extremely fair proposals made consistently by Mr Sinclair.
Wasn't the response that they were waiting to see the outcome of the Guernsey financial services?
My note, my lady, invites the court to look at pages. This is the responsive letters to those letters that I've identified. To page 1493, refusing a fresh valuation on the basis that the parties should essentially take the KPMG report. That's 1493, 1503 to 1504, insisting on the independence of KPMG. 1507, again insisting on KPMG. It may well be, my lady, that somewhere in the correspondence, which is voluminous, I regret to say.
Well, I'm looking at 1521.
Thank you, my lady.
About the problem of that.
Well, to which the answer, one might say, is if that's a valuation issue, that's something that can be taken into account by the independent valuer.
Just going back to the overall scheme of it. Say, for instance, the shares were issued for an improper purpose, and that would mean that the shares should be set aside. And then my understanding was you say that amounts to the unfairness. There's obviously prejudice, there is unfairness. And what is proposed to be litigated further is whether there is such a proportionate unfairness on the part of Mr Sinclair that it's inappropriate for the court to order a sale of his shares at an independent valuation in circumstances whereas here he hasn't breached any duty.
Quite. I mean, the phrase rearguard action springs to mind, and that's essentially what Mr Lightman, on instructions of course, has proposed to this court, to just let litigation continue unabated in the RC until my client becomes too exhausted by this litigation or runs out of money. I don't know. But it's not something this court should entertain, in my respectful submission. I've got 5 minutes or 6 minutes left to go. I'm going to just deal with two further points. The various questions were rightly posed to my learned friend to the effect that there must be an irrationality, a bar, both under Section 295 and at the very least at common law. My learned friend was hesitant to give an answer to that, and one understands forensically the difficult position he was put in by those questions. It is emphatically our case, amongst many other points, that the decision to issue the shares at £260,000 and £2 was irrational. We make that perfectly plain in our case at paras 126 and 127. And the irrationality, my lords and my lady, can be seen in two separate ways. Irrationality one is just alighting upon this totally bizarre number. My Lord Leggett made a number of observations about that. I can't improve upon them. Totally bizarre, £260,000 figure. But irrationality, too, is the belief, a completely bizarre belief, as I think, again, it was suggested no lawyer could possibly have thought this, that the undertaking supposedly put forward protected Mr Sinclair. And those irrationalities walk side by side. My learned friend was given every opportunity to explain them. He was, and I don't blame him for 1 second in the predicament he was in, he was quite unable to provide any sort of explanation as to how these directors could have come to the decision they came to, even if the only bar or the only break upon directors' decision-making under either common law or Section 9(5 is irrationality. And I say it is much higher than that. But if I'm wrong on all that, and it's irrationality, then we are well over the irrationality threshold, given the remarkable facts unfolded by this case. I'm going to make one more submission, then I'm going to hand over to Mr. Loveday to make a 2-minute submission on the pleadings. I'm not going to deal with it myself. My learned friend was driven to suggest, albeit I think he may have tried to resile from that at a later stage, that Lord Wright's dictum, time-honoured dictum cited so many times subsequently, was wrong. He then, at a later stage in his submission, said, well, if it was interpreted in a way which is, frankly, a contortion of the words of Lord Wright, then it might be just about right. There's news that Lord Wright had got it completely wrong would be news to the English Court of Appeal, a case your lordships and my lady have not been yet shown, Magic Investments. I'm not going to take your lordships and my lady to it. It's at 2995. It's a decision of the Court of Appeal in the bundle from this year, where a constitution, including Lord Justice Newey, concluded that and proceeded on the basis that Lord Wright's dictum was correct and represented.
Paragraph?
That's paragraph 13. I think it's paragraph 39. Is that, am I right? Paragraph 39 to 42, my lady. I apologise for not having that at the tip of my fingertip, so to speak. That would be worth considering in my respectful submission. There is some point made on the pleadings. I'm going to give my learned friend, Mr. Loveday, who's been very patient, 3 minutes, if you don't mind.
Yes.
I'm going to sit down.
Thank you, Mr. Grant. We're grateful.
Thank
Mr.
you so
Loveday.
much. Thank you so much, my lady and my lords.
So I'll deal with this in fairly short order, my lords and my lady. The overarching point, of course, is that Mr. Sinclair doesn't rely on a freestanding breach of a duty to take relevant factors into account. We talk at paragraph 106 and 115 of our written case about how that forms part of the assessment on the various duties that we discuss under ground 2. And Mr. Grant spoke yesterday about how that may be analysed as a duty to act fairly as part of what we call domestically the 1721F duty, or it can be analysed as a duty of care or a freestanding duty of its own kind. But in any event, the directors' reasoning and their deliberative process was squarely the subject of factual inquiry from the outset of this case. The pleading is at page 642, and I'm not going to go through it at this stage given time, but paragraphs 20, 21 and 24 all talk about what the directors' reasoning was in reaching the valuation and the different aspects of that. This was discussed and attacked at length in cross-examination at trial, including specifically on a failure to take into account the KPMG report and failure to take into account other evidence known to the directors. That can be found, for example, in the Royal Court judgment 217 to 219 for Ms. Guillou and 249 and 255 to 256 for Mr. Bright. And the Royal Court, of course, engaged with all this evidence and made findings on it. Before the Court of Appeal, it was further distilled, and at this stage we expressly talk about taking relevant factors into account. That is at para 139.3 of our appeal skeleton at page 74 of the bundle, and then at para 148 of that skeleton, pages 76 to 77. And the respondents received that skeleton and filed a responsive skeleton, and at no point before the Court of Appeal was a pleading point taken on this issue. And again, the Court of Appeal dealt substantively with these arguments at paragraph 70. So these issues were fairly raised, they were fairly debated, and in any event, they do fall squarely within the original pleading. Unless I can assist.
Thank you. Mr. Loveday, short and sweet. Thank you very much.
Well, before you write, my learned friend for the first time has indicated that the court should make orders in share purchase order on terms. Paragraph 132 of his written case, which is page 1955, he said if he's entitled to a buyout order or equivalent relief with its terms to be determined by remitting a case back to the Royal Court. That's page 1955. I understood my learned friend to be resiling from that in his closing just now. What we say is all of these issues, for example, data valuation, is an important issue. It hasn't been the subject of any argument before the court. I did raise that in a skeleton argument before the Royal Court, paragraphs 147 to 153 of their trial skeleton, page 631, the respondents did raise arguments against the making of a share purchase order by reference to Mr. Sinclair's own conduct, and the Royal Court did not address or adjudicate on those points. And I submit that those issues should properly be remitted back, or at very least, if the court were minded otherwise, that we should have the opportunity to make submissions to the court on any issues other than the remittance back to the jurats or to the Royal Court of the terms of a buyout order, because that's not a matter we've come here to argue. They are matters of importance to both parties, and if the court were minded to consider not just remitting back a share purchase order or any other such order, but actually to impose terms and determine any of the terms, we should have the opportunity to make submissions to the court on that. But our primary position is, as indeed was the position of the appellants, that the terms should be determined by remitting case back to Royal Court. One final point, my Lord, on the issue of London School of the London School of Electronics. I just want to refer, my Lord Snowden, to Joffrey on minority shareholders, paragraph 5.338. There are two dual issues.
Sorry, 5.338.
5.338, page 325. There were two issues in London School of Electronics. One was removal of a director and whether his conduct could justify his removal. And the second issue was, as a heading of this section of Joffrey heads, the effect on the petition of the petitioner's conduct. So there were two separate issues that London School of Electronics was an authority for. One was, does your conduct justify your removal, where, let's say as a quasi-partner, you had otherwise an entitlement to remain a director? That's one issue. And the second issue was, does your own misconduct, or just conduct in general, could it disentitle you from relief that you might otherwise get? So, my Lord, that Joffrey at 5338, page 325, does identify that second point. Would say, Lord Short, that in fact it is authority for both those propositions.
Yes, thank you, Mr. Lightman. We will ask for them. I'm sorry,
I was almost minded to say, why don't you just put a document which sets out what you see, how this should be sold, how they should be done.
We're very grateful to counsel in the case for the written and oral submissions. We're also very grateful to those sitting behind you for the preparation of the case. This is an important matter, and we will take time to consider our decision, and the court is now adjourned. We're very grateful to you all.
Thank you very much, Mark.